right. I think that's everything. Melinda, take it away.
Oh, okay, just a couple of more things here. Let me just, oh, trying to advance my slide here. There we go. Our presenter tonight is attorney Melinda Gustafson Gervasi, founder of the Gustafson Gervasi Law Office, which has been operating in Madison since 2005. Melinda holds a bachelor's degree from UW-Madison, a master's of public administration from the University of Southern California, and a law degree from the University of Wisconsin Law School. Melinda's current practice focuses on estate planning and probate, where she guides clients through the process of creating an estate plan, as well as administering probate and trust matters. Education is a key component of Melinda's legal practice, which I can attest to, as she has been providing this material for UW Extension audiences for the past 14 years. She is a member of the Legal Association of Women, the former chairperson of the Dane County Ethics Board, a member of the Madison College Foundation Board of Directors, and author of the book Middle Class Philanthropist: How Anyone Can Leave a Legacy. Melinda also has her own blog and can be found on Twitter. Believe it or not, this is only a snapshot of her accomplishments and activities, but I'm afraid if I keep going, there won't be any time left for her presentation. So I encourage you all to refer to your handout for her complete bio and contact information. Before I turn it over to Melinda, I would like to point out that the handout that we provided to you entitled Estate Planning 101, The Basics of Powers of Attorney, Wills, Trust, Probate, and Charitable Giving is solely intended to accompany this educational seminar and should not be taken for legal advice. Please consult an attorney for advice specific to your situation. So now, without further delay, I will turn things over to attorney Melinda Gustafson Gervasi. Melinda?
Thank you, Deb, and thank you, Chip. I assume everyone can still hear me okay. I haven't adjusted anything here, so people are nodding. Wonderful. Well, thank you for joining us here tonight on Zoom. 14 years of giving presentations, and this is our first Zoom presentation. I know that they've had a lot of interest in the sign up. I will do my best to make this as conversational as possible. That's what I do if I were standing in front of you in a room that we were together in. So in terms of things, thank you, Deb, for pointing out that I am here tonight as an educator. I am not here as your attorney, so I cannot give you legal advice. I can certainly help you think about situations, think about resources, explain some terminology, but I'm not able to give you a firm legal opinion on something. So if you do have a question and I can't give you the answer, I'm sorry, but it is considered malpractice to do that if I don't know your complete situation. As for questions, as we go through the material, I'm fine if you want to pose those questions. We are going to be doing that this evening through the chat box. If you just want to type those in, I'll do my best to see them. And I know Chip is going to be a backup for me if they start going quickly and I miss one. Do remember that this is going to be a recorded presentation. And so if you have something that's more private that you don't want to share in a group setting or let alone have it recorded, you're always welcome to email or call me and I can help you again as an educator to think about your situation. You'll have my contact information. It's on the front page of our handout. In terms of the handout, I know not everyone has access to a printer if they're working from home. And so if you need a hard copy, feel free to call or email my office and I'll have my office manager send one out to you. In terms of the website, you can go there if you'd like to link to the blog that I write. And I also have a newsletter that I do every January and every July. And the summer newsletter is posted there if you'd like to read it. And if you're interested in getting one of those, they are sent out in the US mail. You can just send me your mailing address and we'll put you on that. It's not used for any other purposes. So I think with that, I've kind of covered a little bit of housekeeping and we'll go ahead and start talking about estate planning. So estate planning, it can be kind of a grand term that I think turns some people off and they think, well, I don't need an estate plan. That's for people with butlers and fancy, Mercedes or Rolls Royces. And really that can be any farther from the truth. Estate planning is three things. It's planning for illness, death, and taxes. not the cheeriest of topics, but something we all will face at one point or another. So as we march through this material, if you're a visual learner like myself, know that we're going to have one section that's planning for illness, one section about planning for death, and one section about planning for taxes. And so we'll try to keep those in those groupings to make it a little bit easier for you to retain the information. I will point out that anyone who is 18 and older is an adult, and they should have an estate plan as well. Because as we know, with current times and just following the news, accidents happen no matter the age you are. And an estate plan is an important thing to have in place. So what is an estate plan? Essentially, it's going to be powers of attorney. Here in Wisconsin, a form called authorization for final disposition, beneficiary forms on your retirement or life insurances, and a will, and sometimes a trust. And there's tons of different types of trusts, so we'll talk about that in a broad category later on in the material. Why should you create an estate plan? Or why should you update an estate plan? To me, it comes down to one word, and that word is control. By doing an estate plan, whether creating one or updating one, you are taking control of the situation. If you don't, someone else is going to be making decisions about who does what and where things should go, and you are the best person to make those decisions. And so the only way to have that done, that it's legally empowered, is to do the documents that make up an estate plan. If you wish to reduce the cost and the stress on your loved ones, doing an estate plan is one way to ease that for them. It's never easy when we've lost someone who's close to us, or someone is suffering a severe illness. But having this bit of paperwork organized and together can make a huge difference in your loved ones' lives. If anyone out there is like me and has minor children, mine are 12 and 10, and you need to name a guardian for your children, the only way you can do that is through your will. Having, a godparent isn't going to be sufficient for the court. Telling your mother who you want to raise the children is not sufficient for the court. And I know that this can be one of the stumbling blocks for many couples, because they just can't agree on who should be the guardian, or they just don't want to think about that. I would urge you to think about what it would be like for a child or children to have lost their parent or parents, and then have a dispute about who's going to raise them. So again, you're taking control. You're never going to find someone to replace you, but think about who shares your views on education, finances, religion, has a life that's somewhat similar to yours in its pattern. And then the last reason I think I have pointed out here on page 1 about why you should create an estate plan is many people are in a partnered relationship, but they're not legally connected in any way. And that runs the risk of that person being denied the ability to have the rights and the responsibilities you might want them to have during your illness or upon your passing. So for anyone in a partnered relationship, you should really consider doing an estate plan. And so, one more, next page. When to create an estate plan. Apparently, when to create an estate plan is in the middle of a pandemic, because not only my office, but estate planning attorneys across the country have had a huge surge in demand for these documents to either update outdated plans or create them for the first time. In general, I always say it's important to create or update your estate plan when there's a change in family status. So that's a marriage, a birth, a death, a divorce. Those are all points in time when you should look at your paperwork and see, does something need to be changed? People often ask me, what time frame? Should I update it every 10 years? And unfortunately, it's not really a time-specific update that you need, but it's a fact-specific update. You could have a marriage, a birth, and a divorce all within your family in 1 year. And that would be requiring some changes, most likely. The purchase or sale of a home often coincides with major changes in your life, which may also be a reason to update your plan. And then building on that, you'll see change in residence to a different state. My kids and I love to play that license plate game, when we're traveling, which hasn't been in the past year, but I always joke with them, there's 50 different states, there's 50 different license plates. Well, just like that, estate planning and probate laws are written by state legislatures, which means we have 50 different sets of laws related to estate planning and probate. And so if you're like a whole host of my clients who have given up on the Wisconsin weather where, it snows one week and then it's 50 the next day, they're moving to Arizona. A lot of people have done that. Well, when they do move their residence from one state to another, they need a new estate plan. There's a chance that the will carry over. Courts often bend over backwards in order to follow a will because they just want to move things along. But powers of attorney are very important and they're very state specific. And so I would urge people, if they're have a move in their future, or they have moved here, perhaps to be closer to family, to make sure that they have Wisconsin documents. Sometimes people say, well, how do I know? I spend, 5 months in Arizona and the rest of the time up here. A couple of key factors I would look at to know if you've changed your residence, the state for residence, would be what's on your driver's license. Where are you filing state income taxes? And to me, the big one is where do you vote? You should only be voting in one state. So if you have 2 states, you need a different lawyer for a different subject area. But where you're voting. So you would look at those things and figure out where is your state of residence. And once you have that, you can sort of move forward. Those are my general comments. And now I want to kind of go into those 3 silos that I had talked about. And we're going to start with planning for illness. And so as a reminder, Wisconsin is one of 50 states. And so we have our own sets of laws here. Terminology, titles can be very different from one state to another, but they do have the same ultimate purpose. So a power of attorney is a document that says, if I'm alive, but I'm too sick, I want the following person or persons to be in charge of either my finances or my healthcare. And so in this section, there's really 4 documents I'm going to talk about. I'm going to start out with your power of attorney for healthcare. And so a power of attorney for healthcare is a document that says, if I'm alive, but I'm too sick to make my healthcare decisions, this is the person I want to make them for me. And if they can't, then a backup. And this is a very important document to do. If you don't, what happens? If you're suddenly ill and you don't have a power of attorney, under Wisconsin law, even your spouse would need to go through a guardianship proceeding, which means they're going to hire an attorney to petition the court, which means ask the court for guardianship over both your person, which means your healthcare, and your estate, which means your finances. So having a power of attorney for healthcare avoids that whole process. It's a lot less expensive. You can actually do these all on your own with free government documents that are noted on a website on the next page. But we're not a next of kin state, so there's no automatic presumption that spouses can act or adult children could act or your siblings could act. And as a conversation I had with my clients earlier today, they have a 20-year-old son. They have no ability to make healthcare decisions for him should he fall ill because he's a legal adult. So power of attorney for healthcare, who's going to make those healthcare decisions? I really recommend that you give some thought to who is the proper person for this role. Oftentimes I'll see people who have kind of a knee-jerk response. I'm going to name my son because he was the firstborn, or I'm going to name my sister because if I don't, she's going to bug me until the day I die that I didn't name her. I really think this is about control. Who is the best person in your life to take this responsibility? It does not need to be a relative. It can be, part of your chosen family. We have family that share our genetics and family tree, and then we also have family that we've gathered over the years that have just become part of that family you put together. I would recommend picking someone who is going to be your advocate, especially in today's healthcare world. Who's going to be your advocate? Who's going to be on the phone on a Friday night at 11 p.m. with hospice? Who is going to be emotionally stable to handle these decisions? My husband's family, they're very lovely, caring people, but several of his uncles just simply cannot stand to be in a hospital, and they're just not, that's not the role for them. So think about who would have the emotional fortitude to do this, because it's not a sprained ankle when this comes into play. Imagine that you're in the ICU at UW. I think very importantly is who's going to follow your wishes. This isn't someone just rolling into town and taking over and making those decisions for you. It's really going to be someone who's going to give the thought to what your wishes are, what they think you would say, and to act appropriately, sort of being your mouthpiece. Lastly is who has the time to dedicate to this. I have lost both of my parents, and I was their power of attorney in both of their final illnesses. And I will say it takes a lot of time. For a period, I would say 8 out of every 10 phone calls I took were related to something with my parents. So you do need to think about who can do that. Proximity can become an issue. Obviously, with the COVID pandemic, we're learning that things can be done remotely, but they're not ideal. So think about those things when you're making these decisions. I will point out that the moment you die, your power of attorney dies with you. So people will not have any authority with this document after your death. And that becomes important about the third document I will talk about. But before we get there, I want to talk about the second document. It's going to be bottom of page 2, the living will. So this actually has several different names. It's the living will, it's a declaration to physicians, it's an advance directive. Basically, they all mean the same thing. And it's you expressing your wishes to your medical team about what you want to have happen if you are in an end of life situation. There's no hope of recovery. It's pretty much those vegetative state situations we hear about. And so do you want a ventilator? Do you want a respirator? Do you want a feeding tube? Do you want a DNR? And so those are the things that you can think about and you can convey in writing to your medical team. The third document is on page 3, power of attorney for finance. And, oftentimes I'll have people say, okay, Melinda, I get it. I need to have these powers of attorney for healthcare so that my spouse can act and my kids are the backup. That makes sense. But why on earth would I need a power of attorney for finance? I'm married and it's Wisconsin. Isn't it marital property? Well, they are correct that we do have marital property here in Wisconsin, but marital property really becomes a topic of discussion when the marriage is ending, either through divorce or through death. And so that becomes, the marital property share. During your life, you can have assets that are in your name that a financial institution is not going to freely discuss with your spouse. Why would that be? Well, there's two kind of scenarios that come to my mind. One is I spent probably 10 years of my practice where the neighbor next door was a family law attorney. Talk to her for 5 minutes and you'll know why you don't want your spouse, who you may still legally be married to, but are in the process of separating from, to be in charge of your finances. In my own office, you'll see situations where one of the spouses is entering into dementia. It may not be obvious to people at the bank or wherever else they might be doing some transactions, but they really don't have the capacity to be doing so. And so one spouse can make the decision that the other spouse is not the person they want acting. So that's why it's not really automatic. I will point out, if you have an IRA, the I stands for individual. Those are an individual account that you have. So IRAs, 401ks, 529s, 403bs, in benefits that you have through your employer. If the Spectrum cable bill is in your name, you are the person who can make decisions about that service, not your spouse. So if a sudden illness were to happen, the power of attorney for healthcare allows someone to basically take control of your finances. And you should ask yourself, who do you trust with your checkbook? This may or may not be the same people you would put in charge of your healthcare. Sometimes it's a very different skill set. And if you look around your circle of family and friends and there is no obvious winner, you might have a lot of creative free spirit types. You can look to an institution. So sometimes your bank, your accountant office, they might service this role. If you're like me and have accounts at the local credit unions, unfortunately, they do not offer this service at this time. I'm always urging them to consider that, but they don't. So that's the power of attorney for finance. I will point out that if you use the free document that is on the government website through Department of Health Services, which is in bold there, about 2/3 of the way down on the handout, be cautious about the power of attorney for finance. The last time I reviewed it, it took effect immediately rather than springing, meaning coming into effect upon your disability or incapacity. 98% of my clients, when they do a power of attorney, want it to come into effect only if they are incapacitated. There has been a trend in some cases for people to want to take it effect immediately. Other clients are just concerned that their kids are too eager to take control. So it's a personal decision, but I point that out in case you're going to be using the free forms, that may not be something that you want. The last form, number 4, that kind of falls under this planning for illness, loops back to what I was saying about the power of attorney for healthcare. But for both healthcare and for finance, the moment you die, those documents' authority end. And a big question becomes funeral planning. So when my father died, it was 11 o'clock on a Friday night. When my mother-in-law died, it was 11 o'clock on Christmas Eve. And in both cases, the families were given 1 hour to tell the hospital which funeral home to use and to make those big decisions. So you're shocked, you're grieving, and you're having to make those decisions. Also, Wisconsin will defer and say, if you haven't said who you want to be in control, it will be done by your statutory relatives. So it does follow kind of the kinship with burial decisions, but it did not with if you're alive and too sick to act. So again, especially for people who are in a partnered relationship, or they want someone from their religious community, or maybe just someone who is more local to be making those decisions, the Wisconsin government created what's called the Wisconsin Authorization for Final Disposition form. And it is available on the website that's listed here, where you can say who's in charge of making those decisions, who's a backup, even who's a third backup, and then what do you want in terms of, burial versus cremation, religious, non-religious, in lieu of flowers, if you want those donated to a charity. So it allows you to capture your thoughts and wishes, put it in a plan for the people that you would then appoint and nominate. In terms of safekeeping of your powers of attorney and this document, healthcare documents and the authorization for final disposition, I recommend you put on file with your medical provider, both maybe your primary care office that you go to, as well as any hospital of record you might have. And then copies would also be given to all of the people that you've empowered through those documents. Power of attorney for finance, generally you'll have a few on hand at your home. And then give them to the people who are appointed. Most banks and accountants' offices and things of that sort tend not to hold on to this paperwork. It's just presented when it's needed. And so those are my comments that we had on the illness section. And I see a couple of questions popped up. So I will read those off and answer. With the free docs on dhs.com, do they need to be notarized? Great question. I don't use their documents, so I can't guide you through how to have them witnessed. I will say that my power of attorney for finance does require a notary, and my healthcare requires 2 witnesses. And very importantly, the witnesses cannot provide your healthcare. So I always kind of joke and tell the story of, I am the first person in my family to go to college, and I kept going. And my family was very happy that I had earned all those degrees, and they're very proud of that. But they never, ever took my legal advice. And so my father completed his power of attorney in the hospital. And the really only 2 people who can do the witnessing for that are the chaplain and the social worker. So you need to be able to make sure both of them are available on site when you're not in x-ray or getting a blood draw and things like that. So the forms that are on the website that are for free have instructions. Follow them to the T and have someone double check them. One thing that I commonly see on self-executed documents where the client has done them on their own is they assume their spouse can just do these things. And so they don't name the spouse. And they end up maybe naming kid 1 and kid 2. They've just written their spouse out of making those decisions. So be careful not to make any assumptions. And they should have a nice checklist as you go through and follow those instructions. The next one was, if you use a banking institution as your POA for finance, can they have access to other banks? So I think the question here is saying, if you created a power of attorney at your local bank, can that power of attorney be used at other financial institutions? Assuming that was the question, without reading what was written for the one bank that you worked with, I can't say for sure, but I highly doubt that that document is transferable or usable at other financial institutions. Generally, they are written to say, if I have accounts here at, local bank, then this person can also act on my behalf, and that they would not carry over to, your accountant's office or to the IRS or to your retirement account. So do keep that in mind. Okay, if there's any other questions, they can pop them up. I don't see any. So we'll move on to the very cheerful topic of planning for death. And this is a really important discussion. I really want the viewers to leave here more informed so that they can make wise consumer decisions. And I say that because when you hit a certain age, you start getting postcards in the mail and then invite you down to the new local restaurant in town for a free fish dinner and a lecture on 110 ways to avoid probate. Be cautious with those. Many times they're not put on by attorneys. They are put on by an LLC that was formed for the purpose of giving a whole bunch of lectures over a 3-month time frame, and then they'll pick up shop and move somewhere else. And oftentimes they're telling people that they need a living trust. And so through this discussion we're going to have here on planning for death and the probate process and the documents involved, I want you to feel a little bit stronger about making a decision about if you need to have one, and to be able to apply a little bit more knowledge to making that decision. Because I still see a lot of clients who will contact me and say, I want to hire you. I want you to draw up my trust. And then I do a little bit of probing, and they don't know why they need a trust. Someone told them they needed one, or they think they needed one. And so you really want to know what you're getting into if you're going down that road. And they serve purposes wonderfully, but they can be overkill in some situations. And I might be one of the only attorneys in the area who says, really think twice about the trust route. But I am, because I want to make sure people are getting documents that they understand, that they can afford, and that they can manage. And trusts are a bit of a thing to manage. So before we get to that, let's cover some basics. So planning for death. This is where we're going to talk about the probate process. And if you read things written by Susie Orman or the like, those are written for a national audience. They are not written specific to Wisconsinites. What is the book that Deb Neubauer's office has published and put together. It is a fantastic overview of estate planning and probate for Wisconsin residents, using the proper terminology. And I think it's like $10, if not free if you download it. Do make sure you read it with the updates in terms of some of the numbers and dollar numbers that are in there. But I recommend that over any kind of mass-produced national documents. But the probate process, it is not as horrendous as you might fear it to be, at least here in Wisconsin. If we lived in Illinois or Florida or California, I would say some pretty different things, but we're here and we're in Wisconsin. Probate is a process by which we are going to transfer the ownership of a certain type of property from the deceased person to the new owner, and in the process, pay off final bills. And so it's kind of a mundane process. And, as we do this, I think it's important to know, as I said, it's going to handle a certain type of property. People own 2 types of property. They own probate property and they own non-probate property. Probate property is anything you own that does not have a co-owner and does not have any sort of named beneficiary. So it's basically just in your name. Non-probate property is property that either has a co-owner or it has a type of beneficiary listed. When it has that co-owner or beneficiary listed, it is a directive about where that asset shall go upon your death. So we call it a direct transfer. It is not part of the probate process. So when you sit down to wrap your head around all of this, you need to get an idea of what kind of asset mix you have, what's probate, what's non-probate, because a will is going to govern the probate process and generally would not govern the non-probate assets that you have. And so on page 4, a will is a legal document that's basically going to tell the court 2 main things. It's going to say who is in charge of the process. Here in Wisconsin, that is known as the personal representative. Down in Illinois, they call it the executor. But we're here in Wisconsin, and it's called the personal representative. The second thing it's going to do is it's going to distribute your probate property. It's going to say where it goes. Now, if we were all in a room together, I would ask you to do a show of hands. Who here does not have a will? And usually I get 2/3 of the room have their hands go up that they don't have a will. And so if you're one of those people and you don't have a will, surprise, it's the gift giving season. You actually do have a will. If you haven't taken the control to put your wishes in writing, the state legislature has assumed what your wishes are, and they're in state statute. So if you die without a will, it's called intestate or intestacy. And your assets, the probate assets, will be distributed according to state statute. So oftentimes when you do a will, you're using it to deviate from state statutes, at least on some level. So again, when you do a will, 2 main things: who's in charge of the process, your personal representative, and where the probate assets are going to go. A little bit more background on your personal representative. Really give thought to who you're going to put in this role. Many times clients will say, I want this to be as easy and as fast for my loved ones as possible. Should I do a will or should I do a trust? And my answer is, I don't care what kind of vehicle you use, a will or a trust. That doesn't matter. What matters is who you put in charge of the process. So I always say aim for Switzerland. Who is neutral, precise, and efficient? Neutral, because if you have close family members where one person is now empowered, I'll see this commonly where there were 5 children, dad had died, and now mom dies, and one of those children is given the power of the checkbook to handle the estate. They're deciding what to sell the car for, what to sell the house for. They're in control. And even if those kids are in their 60s and 70s, they will start acting like a bunch of middle schoolers if they're not processing their emotions correctly. You run that risk. And so my kids only have each other, and I don't want them to jeopardize their sibling relationship because I picked one of them over the other. I've named an institution. So if my husband can't act, our personal representative is an institution. Some clients will name their sibling, so or a sister. And not everyone has children. And so, or they've outlived their children. And so it's important, again, to really consider that personal representative. What does a personal representative do? They are going to file your will with the court. They are going to gather all of your probate assets. So that means they're going to figure out the car, they're going to do the bank, the savings, the CDs, if you had any stock, maybe your house. And they're pretty much going to sell all of that stuff. It's going to get liquidated. All those proceeds are put into what we call the estate of checking account. So a new checking account is created to go along with the probate, and all the probate money falls into that for the most part. And out of there, the final bills are paid. So they're going to be handling your tax return, your final income tax statement, or any other tax matters that you might have. They'll be paying funeral and medical bills and any other claims against your estate. And then what remains is distributed according to either the terms of your will, or if you did not have a will, according to state statute. So, this is where a lot of times the strong type A's are useful, your nurses, your teachers, your engineers, people who are going to be precise, they're going to be efficient, they're going to get this done, or they're going to hire help if they need it. So half of my practice is advising personal representatives through the probate process. And that expense is the expense of the estate, not the person you appoint. And so again, I will say that this is only governing your probate property. A key point that will help you be a wise consumer is the fee. So there is a fee associated with going through probate. You know, there's some like rumor or legend out there that if you don't have a will, the court's going to take 2/3 of your estate. Not true. No basis in fact whatsoever. The fee that's applied is a statutory fee. And here in Wisconsin, the fee is 0.2%. So for every $1,000 the court oversees, they keep 2. In other states, their probate fees can be 6, 8, even 10%, or 0.2. So if you're ever making a decision about whether or not it's cost effective to create one of those living revocable trusts, you can do a quick back of the envelope calculation to determine if like how much probate might cost. So you just add up all the property that's probate, you know, that doesn't have a co-owner, doesn't have a beneficiary, and then you list the value of them. So it might be your house, your car, your bank accounts. And when you get to the end of it, if you have a mortgage, you subtract that value. What remains, you multiply by 0.002, and that will tell you the amount that a probate fee to the court would cost. Probate does not require an attorney. People can do this on their own if they wish. And so I think when you know that, it helps you understand if that $5,000 or $7,000 trust someone is trying to sell you is really cost effective. So that's a very, very important piece of information that's very specific to our circumstances here in Wisconsin. Okay. So before we leave the area of kind of the probate process, are there any other questions to put in your chat? I will talk about one more thing while we do that, and that is what's called the inventory. One of the jobs of your personal representative is to give an accounting, an inventory of your assets to the court so the court knows what it's overseeing. And, you know, you don't have to get overly descriptive. You don't have to say they had, you know, 3 computers and 52 books and 9 sweaters. Instead, it's things like their personal residence, their vehicles, their bank accounts, and then the value of them upon date of death. For personal items, it's just all lumped under the term tangible personal property and given a value that it would take at like an estate sale or in a garage sale. And that, when you do that, that form is where we do this calculation about the 0.0 or 0.02% or 0.2%. And that is also where a mortgage would be noted as well. So just to kind of keep that in mind. As we go through on page 4, avoiding probate. So some people want to avoid or at least minimize probate. And so some of the reasons behind that and some of the situations in which I might have a discussion with my clients about how they might want to look at some of these other mechanisms other than a will. One, probate is public. It's a public process, and it goes, what your assets that you list there are public. They're seen by people who want to file a request. What's needed is kind of a consent and waiver. So for people who are thinking about writing out a child from a will, or writing out their parent from a will, or writing out their siblings from the will, you know, any of those natural statutory heirs. When you do that, you have to get, when you die, the will has to get a consent form from all those people saying that they don't object to who's serving as the personal representative. And it basically gives them the chance to kind of speak up and say, I don't think this will was valid, or I have concerns about this. And so there can be cases where you want to avoid that. And one way is to minimize the number of your assets going through probate, or you avoid it completely. I worked with some clients quite a few years ago now. It was a same-sex couple, but they were not legally married, and were leaving everything to one another, and they wanted to keep it simple. Let's just do a simple will. And so we did. And one of them died very unexpectedly at a rather young age. And everything was going to be going to her partner. However, for the probate process, we had to contact her surviving sibling to make sure that sibling didn't object. And for about a week, the surviving partner was pretty concerned that he was not going to sign off on that. And so one of the ways to avoid that is by avoiding probate. Just give me 1 second here. Sorry about that. I have a 1-year-old kitten. No, I have 2 twin kittens, and one of them is currently banging on my office door. So I just sent a message that he needed to be retrieved because I don't want him to make a Zoom bomb appearance. So when you have a reason to keep things out of the probate process, you can look to minimize or avoid it completely. Another way is if you want to have dead hand control, meaning that you want to control your assets from the grave, and you can do that to an extent. And there's ways to do that, and that's through the trust. And if you just have a lot of, you're frugal, I'm frugal, and if I can avoid the probate fees on some things, I want to. And so there are different mechanisms to do that. And so we can talk about those mechanisms. I do want to point out one thing. People often think, well, if I have a beneficiary or I have a way to transfer my bank account, it'll go to my, whomever's listed right away. And in theory and in general, that's true. It is a direct transfer and it happens quickly. However, I have seen several instances in which the process has been much slower than people would have thought. And that is because of the delay in the issuance of a final death certificate. There's this little concept called the Slayer statute, which says that if you kill someone, you don't get to inherit from them. And so when a person dies and their heir, who's a named beneficiary, files the claim work with the insurance company for the life insurance, that life insurance company wants to make sure you didn't kill them. And so they do that by reviewing what's called a final death certificate, which lists the cause of death. Unfortunately, for deaths that occur outside of a hospital or out of state, that can be a very long process, especially if toxicology tests have to be run. And so I have seen widows who have not been able to access some basic banking accounts or brokerage accounts that were in their spouse's name for up to 9 months while they waited for a death certificate. So I just point that out, that you can hit bumps in the road with this process too. But if we're going to go down that road and we're going to avoid or minimize probate, beneficiary forms, those are associated more commonly with your insurance and your retirement accounts. I will point out that whatever those forms say controls. U.S. Supreme Court ruled on this question 5-6 years ago. And we've heard a lot about the Supreme Court in the news in the past year, and we know that they don't usually agree. On this case, they did, 9-0. It was a case where the decedent had not removed his ex-wife from his retirement account. A will left everything to his daughter. Daughter felt that, well, that was his ex-wife. Why would he want her to have retirement? I got everything on the will. And it went all the way to the Supreme Court. And the Supreme Court came back 9-0. Ex-wife gets the money because a beneficiary form is a contract. And we're not going to undo contracts in America because that's the heart of American commerce. So I'm always surprised. There'll be a few people who go home and they check and see that they do have somebody listed that they don't want listed on their documents. I see a question has just popped up. What is the statutory percentage paid to the personal representative? So we're going back into the world of probate for that question. And a personal representative is entitled up to 2% of the value of the estate, so 2% of what's on the inventory. That is subject to court approval. I will point out that people who do take that, it's considered earned income, and that person needs to report it on their taxes. And so depending on the situation, if they're also inheriting under the will, they may choose not to take the fee because they don't want to have to pay the income tax. That could put them into a higher tax bracket. But the simple answer is up to 2% of the value of the estate. Can you have a will and a trust at the same time for different assets, for example? Great question. If you have a trust, you're going to have a will. And sometimes you have a will that has a trust embedded within it. And yes, you could use them for different assets. So when I get into the trust discussion, we'll flesh that out a little bit more. Back to page 4, towards the bottom, we talked about beneficiaries. Now, the pay on death or transfer on death. This is the same thing as a beneficiary, it just has a slightly different name. The POD, pay on death, is associated with your bank and credit union accounts, and a TOD, transfer on death, is associated with your brokerage accounts. One of the common trends I see is people who just go way over the top and have everything with a beneficiary form, including their checking and their savings account, but they have a house. So you're going to have a situation where when they die, they're going to have a house going through probate, but no liquidity. The money in the checking accounts and things has gone out to the who is ever named, and it's going to go out to them. And then you have money that's in the money that went to the heirs that they're not obligated to use to pay for things like a house. So you have a house sitting in probate, you're going to have snow removal, lawn care, insurance, property insurance, just incidentals related with managing that asset. And so you don't want to have a house in probate with really no cash, because that can just cause a lot of stress and make things more difficult for your personal representative. One second. My apologies. Transfer on death deeds. This is a concept we have here in Wisconsin, and it's become a growing trend across the country. And you'll see it used when you have real estate. So whether it's a condo, whether it's a farm, whether it's your house in town, this is a deed. Really, it's a beneficiary form that you place or layer on top of your deed that says, when I or when we die, this asset property shall pass to so-and-so. And so you're able to pass that without going through probate. The current filing fee is $30 to put that on with the Register of Deeds. And so it can be a very cost-effective way to minimize what's going through probate. There could be some problems. This doesn't fit everyone's situation. So, if you want to leave it to 4 people, I guarantee you those 4 people aren't going to agree on what to do with the property. One of them's going to want to have his investment. One of them's going to want to sell it. One of them's going to keep it as, a family vacation property. So it tends to work best when you have a property that has no debt on it, because if there's debt, someone has to be able to, either take out, a mortgage to pay it off so they can take it. And so it makes it a little bit more difficult. And the more people who are involved, the greater the risk of disagreement. But it is something to investigate. And these are also offered in other states. So Arizona, I brought up before, they have one as well. So you do see a growing number of people who maybe have a condo in one state and their main residence in another. You can potentially use a transfer on death deed to transfer property that's there to someone and stay out of probate in that other state. I'm specifically researching that right now for some clients who have undeveloped land down in Florida that's not worth very much. And so we're going to determine if they still have this, and at what value it is. So that's just one thing to keep in mind. We had a couple of questions come in here. In your will, can you direct who you want your home to go to avoid probate? Good question. The answer is no. If you have a will and if you have probate property, they are going to go through the probate process. The way to pass a home to someone and have it not go through probate isn't by having a will. It would be doing things like the deed I just talked about, or putting that into a trust, which we'll cover here in just a moment. But if something is being distributed via a will, it is going to happen through the probate process. Okay. And there we are, page 5, trusts, the granddaddy of them all. A lot of people will contact me and say, I need a trust. Write one out for me. I would like to point out, there are so many different kinds of trusts. So a lot of times you need to pull back and say, what's your goal or what's your purpose? And then what is the proper document to get you there? A trust can be created during your lifetime, or it can be created at your death. Trusts created during your lifetime are frequently called the living revocable trust. And so it's like a wicker basket, it's a vessel. And you have a trust agreement, which explains how that vessel will work. Who is in charge of it? That's called the trustee. Who is the backup successor trustee? When the assets are in there, how will they be used? Who will have access to them? And then upon your death, where do those assets go? Because it has that last piece, where do the assets in the trust go? It's the equivalent of a beneficiary form and keeps the item out of probate. So if you're going to have a living revocable trust, I think I have a conversation with clients when they have some of the following situations. They own property in multiple states. So I had a client who had a house in Madison, cabin in the UP, and a condo in Arizona. That's a lot of property to be going through 3 different probates. And so it could make sense to create a trust and then fund the trust with all the property. And what a funding the trust means is you're retitling the house and the cabin and the condo from your name. So, if it was my name, it would go from the Melinda Gustafson Gervasi to the Melinda Gustafson Gervasi family, living family trust of December 3rd, 2020. And so if you don't do that, the property's not in the trust. So if you do have loved ones or close family and friends that have created a trust, but they don't know what's in it, it's time to really figure that out. Because if you have a trust, but the property was not put in the name of the trust, that property is still probate property and will go through probate upon death. And that is one of those things that I see crop up when people are doing a lot of things either on their own or working with a group of people that are selling a trust, but they are not actually a licensed attorney. And we had another question that came up. If a house is transferred by transfer on death deed, how does that impact cost basis for the recipient? And how does that impact property taxes? Is it considered an inheritance and exempt from income tax? So good question. A house that is transferred by a transfer on death deed is the same as if, stock were being passed to someone. It is not realized until death. I am not a CPA, but I would assume that you are getting a step up in basis, which means if the house had been bought in 1950 and it is transferred at death by a transfer on death deed in 2020, in 1950 they might have bought it for $20,000 and now it's worth $300,000. The person who now owns the house would have a cost basis of $300,000, so that when they go to sell, if there is a capital gains tax, it would be based off of the $300,000, the appreciated value, as opposed to the original of $20,000. And the property taxes, they're transferred. So whoever, in order to get that property into the name of the new owner listed on the deed, you actually have to file something. So the first step is you, the person with the property, goes to the Register of Deeds and you file a transfer on death deed, and you pay the fee. When you die, the person you've named or people you've named have to fill out paperwork that states that you have died, provide proof of that, pay a filing fee, and then the property will be put into their name. If there are any liens or things like that on the property, a mortgage or unpaid property taxes, those would most likely need to be satisfied before that transfer could take place. And so anything that is comes to you at death is not considered subject to the inheritance tax. We'll talk more about taxes in the next section. Going back to the trust. So a living revocable trust, when there's property in multiple states, I think it's really important to have that discussion. Another is if you just have a lot of probate property. I had a client who had 22 duplexes, and it might make sense to put that property, to transfer all of those into a trust to avoid the potential probate fee. That client opted not to do that, instead used an LLC agreement for each single property because it was a way to get that liability protection in place, but also handle the distribution of the property upon death. So it was like killing, 2 birds with 1 stone. I would say living trusts are also commonly used by people who are in a blended family. So if it's a family where there's children from different marriages, someone can say, when I die, I want my spouse to have X, and I want, Y and Z to go to my children. Or they can say, I want all of this to go into one thing that my spouse can use. And then when my spouse dies, it goes out to my children from my first marriage. And so it's the concept of dead hand control. You're trying to control your assets after your death. So sometimes those are useful. In practice, in practice, they can be pretty messy. So if you have a trust that's set up for the second spouse to enjoy, you are creating a scenario where your children from your first relationship are potentially watching that person, second guessing everything they spend money on and waiting for them to die so they can inherit. But that is a time when people might use that. And I already kind of covered the privacy issue. So living revocable trusts are dense, complicated. When you have one, you need to have what's called a pour over will, which is a simple 2-page will that says anything I forgot to put into my trust, please put into my trust. You'll want to have powers of attorney that specifically empower your agent to put assets into a trust. So for example, if you have a trust and all your assets are in it and you're incapacitated, then you want your agent to be able to handle a situation where maybe you inherit from someone's life insurance and this lump sum of money comes in. You want them to be able to have the power to put it into your trust. So trusts, a living revocable trust is a little bit more dedication. And you need to make sure that the people you appoint to take over for you have the same ability to manage that trust and understand the financial implications as you do. That's not always the case. People sometimes will say, well, dad died 10 years ago and mom died last week. We never did anything when dad died. And that's going to be an oops type of situation. We should have done something. And the oops defense does not get you far with the IRS. And so if the people who are taking over make a mistake, didn't understand something, it can result in some tax consequences. And that made me remember one other point I wanted to share is that when you're having a living revocable trust and you're going to transfer real estate into it, if the real estate has a mortgage on it, you need to be extra special careful because the mortgage is to you. And if you transfer it into a living revocable trust, that might cause a problem with the lender. It may impact your interest rate, and currently interest rates are extremely low, so you wouldn't want to jeopardize that. And I do believe in some situations it can trigger a call for the loan, which means you just have to pay the loan in its entirety. So if you're going to create a living revocable trust, I highly recommend you work with an attorney just to make sure, you're not doing one thing but causing a huge fire in the other area, things that you didn't see coming. There are another type of trust that are much simpler and I think are really nice. They're more affordable and they work well if you want to have a little bit of control over your funds for a period of time. And those are called testamentary trusts. And I have one. It's for our minor children. And so I have a will that says I leave everything to my spouse. If my spouse had died either before me or with me, then a trust will be created through the probate process. The recipe or the formula for the creation of the trust is in my will. And the court would say, kind of like a magic wand, poof, you're now in existence. And it would get a tax number and have a name. And then all of the assets under my will would go into the trust. And then I have it set up so that my life insurance, et cetera, would go into the trust. And the reason is I don't want to leave the money to my kids. They're 10 and 12. Obviously, they are too young to handle that or manage that. And so by putting it into a trust, we have a trustee appointed. And so that trustee would make a decision about whether to make a distribution or not. So if my kids are asking for X, Y, or Z, the trustee would make that distribution. They would make those based on any guidance that we had provided in terms of how we wanted the money spent. And it's meant to be there for their health, education, and welfare. So with a testamentary trust, the money is in trust managed by a trustee, and the heir can come and say, I'd like money for college, or I'd like money for down payment on a home or start a business. So they can request the money. The money is available to them, but they just have to, get the consent of the trustee. So it's a nice check and balance. And even if you have children that are in their teens and early 20s, sometimes they still need this benefit. And as I talk to my clients, sometimes you have a very well-grounded child and you really feel like they would be fine. I always add in a little bit of information kind of from my personal thing that I've seen and experienced, that when both of my parents had passed, I came from a very blue collar family. My mom ran a machine in a plastics factory. So there was not a grand inheritance to be had, but there was a small amount. And they had both had an extremely difficult final 10 years. And my friends knew this. And my friends are well-educated people who are quite frugal and sensible people. And I was shocked because they were encouraging me to go out and buy diamond earrings. And I was like, what? Do you know how much those cost? And, I bought peace of mind instead. But it reinforces or underscores this idea that someone may have your child's ear. They might say, you know, you've been through so much. The proper way to grieve is in Tahiti. Why don't you buy the tickets? So it has a little bit of control and a little bit of protective aspect to it. So the testamentary trust can be used for people with minor children. It can be used for people who have adult children, but people are concerned. Maybe there's a substance abuse or a mental health issue, and they just want to make sure there's some protection around that money so it's not blown in a weekend. You can do a pet trust this way. And so a pet trust is 4 paragraphs that goes into your will that says, I would create a trust. I'm laughing right now because I'm talking about pet trust and my 1-year-old cat is like pounding on the door. So you would place your pet and whatever amount of funds you felt was necessary to go into the trust, so that if that pet needed to find a new home, it's coming with a little bit of a trust fund. And honestly, they are easier to rehome that way. My mom died and had 2 aging diabetic cats. I couldn't take care of them. I had 3 cats of my own and 2 toddlers. But I, you know, they did not have a pet trust, but my pet sitter at the time was a saint and she took them and I helped her with the bills. Many people had said if I had more money, I would take them. So a pet trust is useful if you really want to take care and make sure animals don't end up in a shelter. I also have several clients who own things like alpaca and peacocks and parrots, things that might have a much longer lifespan, horses. And so it's a way to think about that. And you can even do something for a senior member of your family, just to say, I would like this money to be available to supplement their life if they need anything. But if they die and there's money left, then leave it to charity. And when my mother was alive, that's exactly what I had in my documents. So that's the testamentary trust. Because the trust isn't created during your lifetime, and it's only created at death, they're quite flexible. They're far more affordable and a little bit easier to manage. Looks like we had a question come in. Can your adult kids be in charge of the trust if they are the recipients of the trust? In other words, does this trustee have to be different than the recipient? Excellent question. And I'm going to say I would never advise a trustee to be the beneficiary. In some cases, I have seen this done by other law firms, is that they'll appoint, this often happens with a surviving spouse, is one spouse dies, there's the second surviving spouse, but that spouse has a co-trustee with a bank. And that's just to make sure that there's some prudent advice being given, somewhat more historic when it was perceived that the man controlled the finances and the woman would need assistance. We often saw that. So the question is, can your adult kids be in charge? I've never gone down that route because I just think that's setting something up for a really bad scenario. And there's a light going off my brain that could be also a problem with the IRS. So I can't give a firm legal answer to that. But I don't think it's wise to have people be in charge of things when it's really for their benefit. And I also know anything is pretty much a no-no in my office. There's no co-personal representatives. There's no co-trustees. And in some cases, it's prohibited by statute. But when you have anything, one of those is going to turn into a dispute down the road. And the state Supreme Court has made it pretty clear to attorneys that we don't want to see these cases come up to us. We've got too many cases to begin with. So you, the attorney, make your client decide if these people are in a dispute, which one of them wins, which one of them controls, and that would be the primary person. Okay, I think with that's a lot of information to download to people. It's dark, it's cold outside, so I'm trying to keep this as lively as possible. If you have any other questions related to probate or trust, if you want to pop them up right now, I'm going to take a sip of water and then we'll move into talking about taxes. Okay, I'll keep an eye out if anything comes in. But taxes is an important thing to talk about. And the subject or the scope of this discussion has changed a lot since I started 15 years ago. 15 years ago, the estate tax was much more prominent in people's planning than it might be today. What I think is more important are the income tax and the gift taxes. So I just want to start by talking about those. I will remind you, I am not a CPA, but I can spot issues and tell people you need to see a CPA. And I've done that recently with a client. Income tax. So one thing to know is if you're taking care of the affairs for someone, a loved one who's passed away, and you're just kind of doing this all on your own, which you can, you don't have to have an attorney involved, don't forget to file their final income tax. Because as I said before, the oops defense doesn't go far with the IRS. So if a person dies, like my mom died on February 16th of 2014. And so I was taking care of her affairs. And so I had to make sure that any income tax from January 1 through February 16th would have been filed with the IRS, but that paperwork wasn't available until January of 2015. So you might have to wait a whole year. So you could see how someone might forget about that, but you don't want to. Moreover, if the estate had income from February 17th through the end of the year, the estate may have to file an income tax. It's called a fiduciary filing. And some people will be puzzled and say, well, wait a second, the person was dead. How would they have had income? Well, there's a couple of ways an estate can have income. Commonly, we'll see that they were renting out their home. Maybe they had moved to assisted living or something, and they're renting out their home. Well, the home continues to be a rental property, and rent is being paid, and that's considered income. In different times, we've had interest rates that actually generated income. So you might have had interest or dividends being paid on things. So there could be some income being earned. And I believe the threshold is $600. If it's over $600, a return needs to be filed. So my best advice is for those final tax filings, work with a CPA. And one who does the specific filings that are related to these fiduciary returns. I had a situation with a probate where a tax advisor had told my personal representative, yeah, you're good to go. There's no taxes. You can close it on out. And I had looked at the things and my red flag went up, and I asked that they work with a larger firm that handles these 940s and 941s. And turns out the taxes had never been paid on the IRA distribution, and $30,000 in income taxes were still owed by the estate. So we're really glad we didn't try to close that, because that would have been an absolute nightmare, and a nightmare for the personal representative, because they do take on a personal liability when they're acting under that role. So it's always better to pay for the advice of a CPA in advance than to hire one to clean up a mess. So when it comes to taxation, really recommend that. The other income tax issue is a relatively new one. It happened way back in January 1 of this year. You know, this was before Australia was on fire and before, you know, we all learned COVID-19. And so it may have slipped the attention of many people. When a bipartisan bill was passed, and it was signed and took effect on January 1, and it was called the Secure Act. And it did a couple of things where it raised the age that people have to take their mandatory distributions from, Deb is nodding, I think it went from 70.5 years to 72 years. So not only do you have longer to contribute, you don't have to take those until later. The flip side of that is they got rid of what's called the stretch IRA. And so previously, if someone inherited an IRA, they could stretch those distributions out over their lifetime. And the IRS would set that based on their expected, their life expectancy. And the state bar did a really nice piece on this when it happened. And they wrote about, take a 40-year-old woman who in 2019 inherits $500,000, from grandma's IRA. And so she gets it in 2019, and the IRS projects her to live to be 73. So she's going to have 33 years to take her $500,000 out of that account. And do remember that an inherited IRA is not the same thing as an IRA. They are treated differently. With the new law, that 40-year-old now has 10 years to take out the $500,000. And when it comes out, if it's a traditional IRA or it's a traditional 401k or 403b, if it was tax sheltered, when the money comes out, it's taxed as income. And so that 40-year-old is now going to have more income than her job is probably withholding for, could easily put her in a higher tax bracket. And so, if you have a giving and charitable heart, You may want to look to your IRAs as a means of funding some of those if you want to do charitable giving at the end of your life, because in general terms, a qualified 501c3 nonprofit is not going to pay income taxes on something like that. And so some of my clients say, oh, well, that's a nice pool from which to do my charitable giving. So it's just one of those things that if you have some sizable IRAs and you're leaving them to a younger generation that's kind of at the height of their earning capacity and things, and you are concerned about taxes, some people don't care. Some people say, I'll be dead, it's not my concern. Other people really want to minimize that. If you're in that group, I recommend you talk to your financial planner and or accountant just to review that situation. The gift tax I'll talk about next. This is the one tax that people seem to know nothing about, but I see weekly in my office. And so we'll talk about that a little bit more in depth. The gift tax is a tax that is owed when you, the giftor, make a gift that exceeds the amount set by the IRS for that year. And so currently it's $15,000. And I believe I read that in 2021, it will also be $15,000. And what that means is you can give any one person up to $15,000 a year, and you don't need to tell the IRS. Now, this is the IRS code, so there are, of course, tons of exemptions or exceptions. So between spouses doesn't matter, or if you're paying your kids college tuition, it doesn't matter. But if it's over $15,000, you, the giftor, are responsible for a gift tax. And it's pretty obvious. If we write a check for 50 grand, we're going to feel that, and we're going to know we gave $50,000 away. With the gift tax, it sneaks up on people because they're making gifts and they don't realize it. One of the more common things I've seen lately are my older generation clients trying to help the younger generation, which is a great thing. And they want to help them with a down payment on a house, pay off some college debt, maybe start a business. And they give them what they call a loan. They're going to loan them $40,000. But there's no loan paper. There is no interest rate. There's no repayment schedule. It's not a loan. You can call it a loan, but it doesn't mean the IRS is going to see it as a loan. So you run the risk of the IRS finding that and saying, no, that wasn't a loan, that was a gift, and you haven't paid gift taxes and you didn't pay the penalties. You also run the risk that if you die and that kid had gotten, let's say you gave your niece $40,000, but in your will, you're going to leave your estate equally between your 3 nieces. If there's no loan agreement, that one niece just got $40,000 more than the others. Like, she's not required to return that because there's no loan agreement. So that is an area where we can see some gift tax issues pop up. The main area, though, is with beneficiary forms. And there was a couple of years ago where a woman came into my office and she needed some help because her mother, who had been in her 80s, had gone to her bank, and the teller, the bank assistant, they meant well. I know they really meant to help their client, but they created a huge mess. So I do advise you, unless people have a bar number, do not take legal advice from them. I don't give medical advice. I don't give accounting advice. I don't give financial advice. I only give legal advice within my area of focus. So this 80-year-old woman was in at her bank, and the clerk said, why don't we just make things easier? So if something should happen, why don't we just put your daughter on the account so she can just take care of things? And so they did. So she put her daughter as a co-owner on her bank accounts. And a couple of years later, she died, and she had $200,000 in the bank. And her daughter was the co-owner, so it just moved right on over to her daughter. What could be the problem? She had 2 daughters. And her daughter, who got the money, loved her sister and wanted to share. How does she give her sister $100,000 without triggering the gift tax? Because when she was the co-owner and it came to her directly, that was her money. She could do whatever she wants with it. But if she chooses to give it away, that's a gift. And so we worked with her accountant in my office and came up with a very convoluted plan where she would give her sister $15,000. Her husband would give the sister $15,000. They would both do the same to the brother-in-law, make some gifts in December, make some gifts in January, and hope that no one dies in the process. So again, before you start adding people to accounts and things like that, I just can't say enough that it's cheaper to get some advice beforehand than to try to clean up a mess. So that's the gift tax. The estate tax. The estate tax is a tax that is assessed when a person dies if their net worth exceeds a certain amount of money. And in the cases of a married couple, it would be when the second spouse dies. And so when I started my practice, the federal estate tax was an issue if you had more than $1 million when you died. And that was the equity in your home, your retirement accounts, your pension, everything. So it didn't take much to hit $1 million, especially for farmers or people who owned a small business and things like that. Well, over time, that amount increased. It was 2 million, 3.5 million, then it went away. And then it was made $5 million, set permanently by Congress. But what Congress giveth, Congress can take it. And we got rid of the $5 million mark, and it was set at 11. I have it in here. It's like $11.58 million under current law. So if you have less than $11.5 million, you don't have to worry about the estate tax. If you have an excess of that, congratulations. You've either done quite well or someone who did well thought well of you. And so that's when you would have to do the planning. The problem with the law is that it is good until the end of 2025. And on January 1 of 2026, unless the law is changed, which who knows what could happen, it will revert back down to 5 million indexed for inflation. And so when I see clients who carry a $2 or $3 million life insurance policy, or they own, they're a part owner of a farm or a lake property or something like that, that's worth a lot on paper, but maybe doesn't have a lot of liquidity, that doesn't matter. It's based on the value that's there. And it's owed to the IRS within 9 months of death. And so that's why we hear about the estate tax, is that when it does hit, it hits hard. It's approximately 45% tax on the amount above the exemption, and it's owed within 9 months. And it's not just looking at your liquid cash assets. So it is one of the things you're probably going to want to watch. There's a lot of changes coming out of Washington, and we're also looking at a government that's going to have some revenue issues. I had been predicting the Secure Act happening for quite some time, because it was a really easy way to force money out of people's IRAs and collect income tax on it. And so in my newsletter, my January newsletter, I always address these types of tax issues. What are the limits and things like that? So you can either check it online twice a year if you are wanting to be paperless, or you can tell me if you want to be on the mailing list. So with that, I want to switch and talk a little bit about kind of a favorite topic of mine, and that's charitable giving. And I wrote a book. It came out in 2013, and it's a tiny little book. You can read it in an afternoon, but it was really meant to inspire people that anyone, it's called Middle Class Philanthropist, how anyone can leave a legacy. Anyone can make a difference. And I have a lot of my clients, or a lot of the people I know and work with, who are very giving of their time. They are involved in their community and they give time, and they still want to do something, but they don't know how much is going to be left. And so this kind of approach that I talk about is a nice way for you to figure out if there's a slice of the pie of what's left that you'd like to direct to a charity. It's particularly useful if you have a small family and you're not sure where things would go, or if you have been very involved in an area of the economy or the nonprofit world where there's not a lot of compensation, and you want to support them. And it can just sort of brighten the process. I always, kill off people's families when I'm helping them figure out their estate plan. And pre-pandemic, I'd always offer them a Frango mint because I could bring people down. Can't do that now. But what I would do is say, okay, where do you want this to go when you die? Okay, you want it to go to your spouse. And if your spouse had died, okay, well then to the 2 kids. Well, what if something tragic happened and something had happened to the 4 of you? Where then? And I always get the response, I never thought about that. And some people are, leave it to my statutory heirs. Or some people will say, well, my sister has mental illness. She can't inherit. It would disqualify her from her benefits. Or, well, I don't want my brother to have it. I haven't talked to him in 20 years. Or people who are like my sibling, or my sister or my mother or whatever, they're loaded. They don't need the money. And I had a client who worked in the mental health field and said that if she were on a plane going down with her family, she would want to know that her money went someplace where it did the greatest good. And so I do think this is a way to put possibly a positive light on a very dark topic. So why would you want to make a charitable gift? Well, it's a gift that keeps on giving. Expressing gratitude simply feels good. It does set an example for our next generation. I always joke about people who have small children. Sometimes those small children will repeat a 4-letter word that everyone knows they learned from the parent, and the parent blushes deep red. Well, if you don't donate to charity, maybe the next generation will as well. You should give some time about selecting your cause. And ask yourself, we all only get 24 hours, 7 days a week. Where do you give your time? I think that's a really good indication of what you value and what's important to you. And then, where is the financial support needed the most? It could be a certain area within an organization. Or was there something that was particularly important to you getting through your life? I know personally, the UW changed the course of my life. So they would be someone I would want to think about. It's very important to evaluate your charitable organization. And I have a few websites provided here on the handout if you want to look at how they're run and some of their tax reportings and things like that. And very, very important. If you're going to name a nonprofit, make sure you're naming the correct nonprofit. And I have a case cited here that was out of Ohio, I believe. And it was a case involving a distribution to Alzheimer's. And the name that was in the will wasn't really a real organization, but 3 organizations that had similar wording all stepped forward and said, oh, they meant me. And the court ended up just dividing it between the 3 that had stepped forward. So it wasn't the best way to make sure that the decedent's wishes were met. So really make sure you know the legal name. Charity Navigator is where I go when I want to confirm things. I can tell you that a lot of my clients want to name Wort Radio, W-O-R-T. But that's not its name. It's Back Porch Radio Inc. And I know that because I've looked it up enough times. And so making sure you have the complete legal name and potentially including the EIN, which is the tax number, so that we don't have any dispute about a national versus a state chapter of an organization. So to think about that. It is important, I would say, to just to keep tabs on that organization. Here locally, the Henry Vilas Zoo recently went through a pretty significant change and broke its relationship off with the Zoological Society. And I know a lot of people who had named the Zoological Society in their documents. Well, I don't believe they even exist anymore, or if they do, they don't even have a relationship with the zoo. And so in all of my documents, I will put, Charity X or its legal successor organization. So if they change their names, hopefully it will flow with them. Making it legal. Whenever I see nonprofits that ask you to include them in your will or trust, I kind of laugh because not only are they asking for money, but they're asking for you to spend money to go work with a lawyer, which is can cost money, and not everyone likes us. And so it's kind of an unpleasant task. So I always wonder why they don't start at the bottom. In lieu of flowers, you'll see this in a lot of obituaries where people say, in lieu of flowers, please direct donations to. It's a wonderful way, even for someone who had been receiving Medicaid, can be a philanthropist. You can, if you have life insurance, you can leave them a percentage of your life insurance. You don't have to leave them everything, but you can leave a percentage. Same for retirement, PODs. Some of my clients came up with a creative idea. Their mother had a huge, huge home full of stuff. And the children took the things that meant that to them, but they had a ton of stuff left over. And so they had a very creative garage sale. It was donation only. Pick what you want, make a donation, and they had information about the charity, and it was an organization that had meant a great deal to their mother. It cleaned out the house very quickly, and it raised money for a good cause. And I really think it made them feel good about that process. It's very hard to dismantle a parent's home. And then, of course, you could leave a bequest in your will or your trust where you're leaving a dollar amount or a percentage or something like that. I did want to go back over to the questions. Let's see, where did I miss? Here we go. Money directed to a charity, would that lessen any tax burden incurred through the inheritance? The only way that potentially could is if you're in the area of the federal estate tax, because generally there's not a tax on an inheritance here in Wisconsin. Income taxes are an issue for someone inheriting someone's IRA, and that's paid by the person inheriting it if it was sheltered dollars. But then the only estate tax is that tax we discussed earlier if you're in excess of $11 million. And the next question, if you inherit an IRA and then you die before taking all of the distributions, can you designate a beneficiary on your remaining inheritance? Good question. I can't say for certain without looking something like that up, but I do know that when you get an inherited IRA, they usually ask you for your beneficiary form. There might be some implications that are different because they're not inheriting what's considered an IRA, they're inheriting what's considered an inherited IRA. There is a distinction between those two types of accounts that came out of a bankruptcy decision several years ago. But anywhere that you have a financial asset, whether it's in an IRA, a brokerage, a money market, you can usually put a named beneficiary on there. Okay. Good questions. And we're right at 8 o'clock. So I think I'm just going to wrap up here with a few closing remarks, and then we can handle any other questions as they might come up. We already talked about the fact that Wisconsin is a marital property state, but I just want to underscore that when you say I do in Wisconsin, there becomes a very, very strong presumption that those assets will be shared 50-50. And so if you are in a second marriage, or you're coming into a marriage where maybe there's a great deal of wealth on one side and not the other, for whatever reason, you want to treat your money differently than the 50-50 split, you can do a contract with the person you're going to marry. And it's called a marital property agreement. Commonly, they're referred to as a prenup or a postnup. So they can be done pre or post marriage. And it's a contract between two people who say, we're either going to deviate from statutes, and there's a couple of combinations. They might say, everything we brought into this marriage and everything we earn after that fact will remain our individual property. It's commonly used by people in a second marriage where they want to make sure that the assets they brought into that relationship aren't going to go to the spouse, but they're going to go to the children from their prior marriage. And it's usually done by people who feel that they're both financially independent. You can do one that says, everything I brought into this marriage is my individual property, but the things we earn going forward will be marital property. And you can actually have cases where they say, we're a blended family, and what we had before and what we have now, we're going to just treat as marital. And those are sometimes used by people where children are expressing an objection to them marrying someone, and they feel that if they die, their children might make an issue for the surviving spouse. And this is a clear way of saying, nope, I know I have you, but I'm leaving everything to the spouse. And so if you are going to enter into one of those agreements, I highly recommend you work with an attorney. You are deviating from Wisconsin statutes in most cases. And when you do that, if you do not have the advice of independent counsel for both parties, the agreement's probably not worth the paper it was written on. So, and give yourself time. If you think it's going to take you 3 months to do that, you probably should budget 9 months. It's a challenging process. You have to put all of your finances out there and discuss things, and it can open up some, shall we say, dynamic conversations that sometimes happen in the lawyer's office. And safekeeping, particularly important, to talk about. We had the floods that went through 2 or 3 years ago, and I live in an area that was flooded. Our basement had quite a bit of water in it. Nothing compared to many others, though. And when that happened, I just thought about, oh my gosh, all of the people who keep their paperwork in their basement. Was it in a waterproof container? So waterproof, fireproof, those can become issues. So when it comes to a will, I always give my clients their final documents. They get them all, and they need to manage them accordingly. That gives them the power to go to any attorney down the road if they want to as well. They don't have to come back to me. And that's kind of a recommendation now for empowering clients as consumers. When you have them, I recommend people consider putting their original will on file with the Dane County or whatever county they live in's probate court. So here in Dane County, you can put your original will on file with the Dane County Probate Court. They charge $10. It's a one-time fee per will. It goes into a sealed envelope. No one knows what it says. It's put into the safekeeping area. It's given a number. And then when your time comes and probate does need to be opened, the will is already at the probate court and everything else can be filed online. I cannot underscore enough with the pandemic how difficult it has been to deliver paperwork in a secure fashion down to the courthouse. So I have had a significant number of probates this summer. And in the cases where the will was at the probate office already, it was a much smoother process. Powers of attorney, I recommend copies of them. They have the same power as the original. Give them to the people you've empowered and to, healthcare entities that will hold them. And so I know we're right at 8:04. And I think Deb had said that the stop time had been 8 o'clock. I know I dump a lot of information. I know I talk really fast. I tried to limit my coffee consumption today, but there's a lot of information to go through. So lawyers are supposed to give back to the community, and the way I love doing so is through education. So if you have questions that you didn't want to post in a public forum, or if something happens 3 weeks from now and you wish you were, meeting with me at that time, feel free to reach out. So you've got my email, you've got my phone number. I am a solo practitioner, so I answer my own phone, and sometimes I scare people because they don't expect me to answer. But by all means, if I can do something to help out, I know a lot of people have this right at the forefront of their attention, just given the news that we are seeing. So I appreciate everyone who showed up and the questions that you have had. Let me see here. Well, thank you for the thanks. Someone said thank you. In a 50-50 state, and you inherit money, so I believe they mean a marital property state, you inherit money, how can you set the money aside to be inherited by your adult children? Good question. In most states, an inheritance is considered your individual property and not subject to marital property. However, it can quickly become what we call mixed marital property. So if you have an inheritance and it's earning interest, or you're adding to that inheritance through your paycheck and things, it can be difficult. So ideally, you'd have a marital property agreement that says anything that I inherit and anything I add to it would remain my individual property. Well, commonly we'll see this where people, I had one person who was 5th generation farm, and they, the spouse didn't want the farm. They just wanted to pass to the 6th generation. And so you can do a document that would say that as well. So if it's really important to do that, I would recommend you work with an attorney. You might need an hour of their time just so you could get some good housekeeping tips on how to keep that money truly individual, because people might not realize, your paycheck is considered 50-50. And so if you're putting marital property into an inherited asset, you could be mixing it. So it can get complicated quickly. So with that, I'll see if Deb maybe wants to close out with anything else. And I hope you all have a very safe and as healthy as possible winter season, and reach out if I can help.
Great. Thank you so much, Melinda. I have to say that every time I hear you speak, I learn something new. So thank you so much. I just want to draw everybody's attention to checking out Melinda's blog. You can follow her on Twitter. I subscribe to her newsletter, and I find it very, very useful. And I have occasionally picked up the phone or sent her an email, and she is quick to respond. So one thing that she did talk about was the UW Extension publication, Family Estate Planning. And if that's something that you are interested in, you can purchase it. If you want the hard copy, you can do it through the Learning Store that's on this slide. But you can also go to the Learning Store and just view it, open it up and download it, and that you can do for free. So I really encourage you to do it. I look at it quite often. It is pretty intense in terms of a lot of material, but I think you'll find it useful. So with that, thank you everybody for your time and participating. And thank you so much, Melinda, for doing this for us. So
of course, Deb. Always happy to help out.
Good night.
Bye-bye.
Thank
Bye.
you. Bye-bye.